at the risk of adding to the paper before your lordship, of putting in a short supplementary note, just addressing that issue separately on whether a contract is required or not, just to put everything together in one place. So I'm not going to waste my lord's time with things that have already been shown to my lords. But if my lords see the supplementary submissions I put in yesterday, I'll quickly run through those.
Just 1 second,
yes,
as long as we all have it.
You got it?
It's okay. 8 pages.
It's a short one. Right?
It's a short one.
Right.
It's only on this limited aspect, and one new article which I found, which is extremely edifying. I'll go through that. It's a recent article by Bernard Hanisch, who is internationally recognized as the sort of expert on the group of companies doctrine. And he has analyzed the law from all over, including India, and then come out with certain conclusions, which I'll only read the conclusions to my lords. I won't obviously read the whole, it's a very long chapter. We're not coming back to what fell from my lords. And section 7. Lord, section 7, as we saw last time, and if my lords turn straight to page 2 of my note, where I've tried to break up section 7 in para 5. The first part of 7.1 deals with the arbitration agreement. So there must be an agreement by the parties to submit to arbitration all or certain disputes. And 2, the arbitration agreement must be in writing. That is in 7.3. Now, that ends, in that part of 7.1, it ends arbitration. That is a concluded contract. That is required to be a contract. I'll show that. What are the nature of the disputes that can be referred to arbitration under that contract? Then follows. So the disputes could be past or future. The disputes must be in respect of a defined legal relationship. And the disputes could either be contractual or not. And in fact, if my lords would kindly, there's a short compilation with this, a new compilation of authorities, page 141 of that, there is a passage from Russell, which actually puts it very nicely. It's just a sentence I want to read from there, but it really puts it in encapsulated.
Where is that compilation?
What is the compilation? It's called SCC. Part 2 of my compilation. It was filed with the note.
Oh yes, convenience compilation.
Yeah, these are more inconvenience than convenience, I agree with not, but they're always for some reason called.
It is, it's
a page 141.
Is it the supplementary convenience compilation?
Yes, that is the convenience supplementary.
477 pages.
141, if my lords think I. Page 141 of the compilation.
Page?
Page 141 of that supplementary compilation.
Page 144 PDF.
Yes.
Definition, it says, statutory definition of arbitration agreement. This is under the English Act, no doubt.
PDF page.
It says definition in the 96 Act.
140? PDF page.
My lords have that. Section 6 of the Arbitration Act 96, that's the UK Act, contains a definition of an arbitration agreement. It provides that an arbitration agreement is, quote, an agreement to submit to arbitration, present or future disputes, whether they are contractual or not. And then the next sentence. An arbitration agreement is therefore a contractual undertaking by 2 or more parties to resolve disputes by the process of arbitration, even if the disputes themselves are not based on contractual obligations. I would adopt the same submission for our section 7.1. The agreement is a contractual undertaking. The disputes themselves may be contractual or non-contractual. There may be family matters, partition. But to go to arbitration, there must first be a contract. It's not that every family dispute without an arbitration agreement can go to arbitration. There has to still be an arbitration agreement. Similarly, for all the other examples that fell from the bench, torts, quantum meruit, quasi-contract, it requires an arbitration agreement. Now, the fact that an arbitration agreement has to be enforceable in law and therefore a contract, there are several tools that we get from the mathematics of our own law. The most important tool to my mind is found in section 28 of the contract. My lords know section 28 of the Contract Act renders void any contract in restraint of legal proceedings.
Arbitration is an exception.
Exception, and it's referred to as a contract.
One point of distinction so far as the UK law is concerned, they have a separate statutes with respect to rights of third parties.
Yes.
So therefore, that's the point of distinction.
My lord,
Our law in the English.
so do we, and our act deals with that. I'll show that provision also. My lord is actually statutory arbitration. We also have. If my lord sees section 28, agreements in restraint of legal proceedings void, and exception 1. I'm sorry.
Yes.
Exception 1. This section shall not render illegal a contract. Please mark those words. A contract by which two or more persons agree that any dispute which may arise between them in respect to any subject or class of subjects shall be referred to arbitration. So it has to be a contract, otherwise it will be hit by section 28. And contract in the Contract Act is well defined. That is an agreement enforceable at law. How is an arbitration agreement enforceable? And which is the law that enforces it? It's the Arbitration Act. Because under the Arbitration Act, one can enforce an arbitration agreement either by filing a Section 8 application or a Section 11 petition to your lordships or to a high court. And the resultant enforceable degree, Section 36. Similarly, a foreign arbitration, the foreign award is enforceable under 46, 48. So it's enforceable at law. It's enforceable under the provisions of the Arbitration Act itself. And therefore, it is a contract. And if it weren't a contract, it would fall foul of Section 28 of the Contract Act. So it has, and my lords have repeatedly said, and my lords are familiar, I'm not citing those judgments, I've referred to a few of them. Vidya Drolia is the last expression of that it has to be a contract, meeting the requirements of the Contract Act. Your lordships in Bhavan construction, a judgment I put at page 128 of this, Justice Roy was a party to that judgment, also says that arbitration is a creature of contract. Correct, absolutely correct. And then if my lords go to page 3 of the law, running through it, all the material, I don't want to trouble my lords by actually reading everything. So, para 13, I've cited the US Supreme Court. A party cannot be required to submit to arbitration any dispute which he has not agreed to so submit. And it refers to it as a matter of contract. Then Russell, I've shown my lords. And Gary Bourne also says this is a contractual method of resolving disputes. So there can be no doubt that an arbitration agreement has to be a contract. Otherwise, it's meaningless, not enforceable. It would run into the restraint of Section 28. The disputes that can be referred under that contract can be non-contract, no question. Tort, family disputes, even IPR disputes of a certain nature, all that can be. And then at page 3 of my note, I've now analyzed what are the requirements under the Contract Act of a contract. The first is, your lordships in have said this, that mere acquiescence is not enough. There has to be an offer, acceptance, a proposal, and acceptance. And therefore, there has to be reciprocal promise. There has to be an absolute and unqualified acceptance, which has to be expressed in a usual and reasonable manner. Why am I emphasizing this? Because as far as the signatories are concerned, they've signed. That's the acceptance. There's no dispute on that. As far as the non-signatory's acceptance would have to be established in a manner known to the law of contract. That doesn't mean signature. It can be by conduct also. Because acceptance can be by conduct. There's no difficulty on that. But it has to satisfy the threshold of what constitutes acceptance under the contract. Now, all this actually does tie in with the group of companies doctrine. I'll come to that finally. It's not that this takes us away from it, but it definitely requires a scrutiny of the factors that satisfy the group of companies doctrine through the lens of the contract.
Mr. Kambata,
Yes.
this group of companies doctrine and when they define legal relationship
Logic.
and a non-signatory brought in. When you talk about group of companies, there are promoters for a company. Promoters may not be taking a decision for company X,
Logic.
but the promoters are of company X, Y, Z.
Yes.
Now, perhaps an attempt is being made that the promoters who might have been, looking at the promoters, people might have entered into contract with, say, company Y.
Yes.
Promoters are also being looked in who otherwise have no connection, nor they are significant.
Correct.
So, what is the interplay? Perhaps in a company situation, there's a board of directors which take the decision.
Logic.
Would you like to sort of?
Yes, Manoj, I think that's a very good question. And maybe go straight to page 7 of this note. I've actually addressed this very issue. Fell from my lord on the last occasion. Therefore,
That's why it was.
I have addressed it not specific. We can go to it straight away.
No, you may go in your own flow, but
I don't mind going to it straight away.
No, you may
These are issues that arise.
go in your own flow and then come to.
Very good. I'm certainly going to address it.
Right.
It's a very important aspect. You know, coming back to where I was, therefore, 24 of my note, para 23, consent as defined under section 13 of the contract. Two or more persons are said to consent. We agree upon the same thing in the same sense. Consensus had idea. So, in the para 24, I've tried to summarize. In the context of the group of companies doctrine, one, there must be consensus ad idem. That is a mutual intention on the part of all parties, both signatories and non-signatories, to be bound by the arbitration agreement. Two, there must be absolute and unqualified acceptance by the non-signatory. Three, this acceptance may be expressed or implied. Usually in the context of group of companies, it is likely that the acceptance will be implied. Such implied acceptance manifests in negotiations, performance, and termination, if applicable, of the contract. And that is why, my lords, in the ONGC discovery judgment, have added a very critical fifth factor to chlorocontrol. It was not there in chlorocontrol, it's performance. That is a fundamental factor. Then four, such participation in the contract through negotiations, performance, and termination, if applicable, must absolutely and unequivocally show the non-signatories' acceptance of the contract as a veritable party to the same. In other words, and this is put very well by William Parr in a passage cited in Cox and Kings, where he says, the fact that a non might be bound to arbitrate does not dispense with the need for an arbitration agreement. It only means that the agreement takes its binding force through some circumstance other than the formality of signature. So you still need a contract, but you need not have a signature, because you can say that a party has orally agreed to an arbitration, performance, taking on of obligations, has effectively and impliedly consented or accepted that arbitration agreement. So I'm not for one moment suggesting that this argument excludes the group of companies doctrine. Of course not. But this is now my alternative argument, that even if space is found within section 7, there are still certain cardinal limitations. And the reason why I'm emphasizing this is that our country, India, has actually gone to an extreme with respect to the group of companies doctrine. We see the law from all over the world. It is hedged in with guardrails and restrictions. India is perceived as they call it, the most liberal as far as this doctrine is concerned. Now, that's not a bad thing in itself. One must keep in mind that going to one extreme will also open floodgates. And India will thereafter not become attractive as a seat for arbitration for example, a group or a foreign multinational or even an Indian. with companies where it wants to have a structure where it ring fences certain companies with the contract. They have nothing to do with the contract. But because of the manner in which some of our High Court decisions reached out, any creditworthy member of the group is brought into the arbitration. So that is, my endeavor is to satisfy my laws that there is need now for some guardrails to be put on the chloro-control doctrine. It cannot be unrestricted or unqualified. That is actually something that works against arbitration. Because the general impression of the other side is group of companies doctrine, pro-arbitration, we must propound it. No doubt about that, but with certain guardrails. Only then will it become an effective doctrine. And guardrails to the extent that it cannot intersect and be destructive of other very well established, like the right of a corporate group to structure itself, short of fraud circumvention. I'm obviously not talking about those cases. Those cases, my lords have always been able to look through, always pierce the corporate veil. So fraud, deception, circumvention are out. But short of that, there's no reason why, as in tax planning, one can't arrange one's affairs. The whole line from our Constitution Bench decision in Dunlop, and then as explained in Azadi Bachao, saying there's no reason why you can't organize your affairs. Now, giving unrestricted vent to the group of companies doctrine will ride a coach and forth through all those other doctrines. Therefore, the doctrine of concluded contract will go. The doctrine of structuring your affairs in a particular manner will go. The doctrine of party autonomy and consensual nature of arbitration will go. If the group of companies doctrine is interpreted as so far-reaching as to reach out to any part of the group. And that's the reason why I would submit that it is necessary for your law now to lay down this stuff. It's not enough to say that there are judgments Supreme Court and that's enough, which is what my learned friends say. So when we see those judgments, and I'm not going to trouble my laws with those, everyone has read those, they don't have these guardrails. They are even chloro controls. For example, chloro control is the most important guardrail of performance. It's not there in chloro. So it is necessary. Now, may I just show your lordship judgment in ONGC and discovery, which is in my main compilation at page 838. The first compilation that I filed, volume 1.
Just one second. ये कहाँ पर होगा?
Page 1.
Yes, that yes. At 805.
Give it to the bishop.
Forty
Compilations
I
that
filed.
your office.
One
What
was the
page?
long one,
805 PDF.
with about 1500 pages.
Yes.
And then second is yesterday's.
That's
The length is only because we put in the entire document actually.
Convenience compilation, yes. Page 805.
805 at 845 is para 40. It actually neatly summarizes chloro controls and adds one factor. So at the bottom of page 840.